Hello and welcome back to the Neutral Voice. I am Samung Debbarma, and this podcast series is a space for thoughtful conversations on neutrality, judgment, and professional responsibility, grounded in real experience across disciplines where these decisions shape outcomes beyond the room. Today we are joined by Ms. Berin Hikmet, a barrister whose work focuses on international arbitration and investor-state disputes, drawing on experience across criminal advocacy and public international law. She brings a thoughtful perspective on neutrality, legitimacy, and trust in complex dispute resolution systems. Ms. Hikmet, thank you so much for joining us.
Thank you for having me.
So, to begin, you began your career in criminal advocacy before moving into complex international disputes. Looking back, what carried over between those worlds and what had to change completely?
Well, that's a very interesting question because I thoroughly enjoyed my work at the criminal bar. And as a young barrister at the criminal bar, you get excellent advocacy training. You're in court every day, you learn how to address very different audience, randomly selected 12 members of the jury, the resident judge, at times the Court of Appeal, a High Court judge. There is less written, more oral advocacy. You very often have to make off-the-cuff legal arguments, which is very useful because you learn to be quick on your feet. But advocacy may become theatrical at times. But so I would say, firstly, that you leave the theatrics behind. What you carry over is the importance of reading the room and reading your audience. As most of your submissions are done in writing, the oral advocacy becomes more restrained and concise. In some ways, more demanding, actually. Final note, less theatrics, more precision, I would say.
Thank you for very briefly describing your journey. So, now, coming to your present area of practice, which involves investor state and public international law disputes, parties often come with very different levels of power, visibility, or resources. From your experience, how does that affect how disputes are argued and perceived?
Yes, power differences are more visible in investor-state disputes than your normal international commercial disputes. But they don't operate only through the obvious more resources or formal status of host state versus the investor. They also come up in confidence, familiarity with the system, and the ability to shape the narrative from the outset. So some parties arrive, in other words, fluent in the language of international arbitration. Others are still translating their experience into that framework. And that's the simplest way of explaining what I mean. For example, I think most striking example for me is we represented a host state, a team of us, back to back in 7 cases. And these cases last 3 to 5 years. They're not short cases. Perhaps more striking advantage in these cases, as opposed to having 7 cases back to back, we knew our clients, their restraints as a state, and their resources. So our communication was very simple by the end of the first case. And 4 out of those 7 cases involved the same bilateral treaty. You may or you may not know, in an investment arbitration, a dispute arises out of a bilateral treaty why the state parties promise each other that they would protect each other's citizens as investors in their territory. So in 4 of those cases, we had the same BIT, and we've had to make the same legal argument involving the same dispute resolution with different claimants. In other words, we had a lot of practice on the same issue. So in terms of power goes, if that makes us more, as a team of lawyers, worse than our opponents. I would like to note that we did not achieve the same results from all the tribunals. So in that case, practice didn't make perfect, if you see what I mean. But as a neutral, one would have to ensure that due process is observed, bearing in mind the subtle asymmetry of power, knowledge, and familiarity. And as an advocate, I think the most important thing is being aware of the asymmetry of power internally and strategically. What do I mean by that? You do not dramatize them in a way that feels manipulative or political. This can backfire, as the tribunal may have to step in to help the less advantaged side to compensate for the imbalance. So my opinion is, be proportionate, do not exaggerate, build credibility over time with your tribunal, with your with your team. Even when a tribunal is neutral, if an argument appears opportunistic, it can undermine the confidence in the process.
Okay. Thank you. The thing you mentioned about the bilateral treaties in investor-state issues, I think that's something new to me. And besides that, the asymmetries between the parties, as you mentioned, I think that is also very insightful. So, since you mentioned about tribunals, international arbitration depends heavily on the perceived neutrality of tribunals. What, in your view, most strengthens or weakens that perception of legitimacy in investor state disputes?
Few things come to mind when you say perception of legitimacy. I think they're just strengthened when appointment processes of tribunals are transparent and when reasoning of the tribunal is rigorous. When tribunals clearly demonstrate that all arguments have been taken seriously. Those would be my main point. But what weakens the legitimacy is not so much disagreement with the outcomes, but a sense that the process was closed, predictable, or influenced by repeat dynamics. In high-stakes disputes involving public interest, neutrality has to be visible as well as real. My example of that would be repeat appointments of an arbitrator by a certain party or council may be problematic in this respect. Even where no actual bias exists, frequent appointments of the same arbitrators by the same types of parties even can create a perception of predictability or alignment, which risks undermining confidence in the tribunal's independence and impartiality. Well, in investor-state disputes, there's no precedent. So prior decisions can carry persuasive value, but does not bind the next tribunal's decision. But even then, a lot of work goes into nominating and appointing an arbitrator in any particular case. After identification of the issues in the case, we look into the arbitrator's public decisions, articles, and attempt to determine really their general views on the issues in question. Some would say it is by far the most important decision we make as counsel in the case. Under the same breath, I would like to mention that some arbitrators are perceived to be much more aligned with host states and are repeatedly appointed by counsel on the state side. This may naturally undermine the perception of impartiality of neutrals and weaken the perception of legitimacy. I mean, my advice to counsel is that there is a large pool of arbitrators, but there is a smaller pool of appointees, the usual suspects, I would call them. It would really help to protect the legitimacy of the process if we, as counsel, avoid repeat appointments of the usual suspects and go outside our small pool.
Okay, I think that aptly answers the question. So, as an advocate, how do you approach persuasion in forums that are designed to be neutral and institutionally restrained?
Having mentioned criminal trials, I'll go back to that. Advocacy in systems built on neutrality requires a different kind of discipline. For instance, advocacy before juries, persuasion often relies on emphasis, narrative force, and strategic simplification. You're expected to argue with conviction and to press your case hard within an adversarial frame. In international arbitration, the dynamic is very different. The tribunal is not looking to be persuaded through force of delivery, but through precision, as I said, restraint, and exercise of judgment. That changes how advocacy works. Persuasion becomes as much more about what you choose not to argue as what you do. You make concessions, you have to be more proportional, and intellectual honesty, I think, becomes tools rather than weaknesses. When advocacy is calibrated in that way, it doesn't just advance a party's case, it reinforces confidence in the neutrality of the process itself. For example, it's often more effective to acknowledge where the situation is complicated, explain why certain details matter more than others, and be clear about the limits of your argument. Then kind of openness tends to build credibility rather than weaken it. In this context, I think advocacy isn't about winning every point. It's about helping the decision makers reach a fair and reasoned outcome. So when that happens, it not only strengthens your case, but also reinforces confidence.
Okay, thank you. So moving on, in disputes involving states, investors, and public interest, outcomes matter. But so does how these outcomes are reached. So why do you think trust in the process itself becomes as important as the legal result?
Well, the famous maxim, justice must not only be done, it must be seen to be done. In disputes involving states and public interests, the outcome is only part of the story. Even a legally sound decision can fail if the process isn't trusted. Parties need to feel heard, and observers need to understand how conclusions were reached. So trust in the process is what allows decisions to be accepted, even when they are unpopular by your client. It's also what sustains the system over time. Without the procedural confidence, the legal result alone isn't enough to maintain legitimacy. I had one client who kept saying that the institution or the tribunal would find the issues to be political, and he feared that they would not do justice to our case, partly because of the asymmetry of power in the political arena. In such cases, I explained the process, starting from the beginning, starting from registration of the request of arbitration, the selection of arbitrators, how the system of neutrals is protected through arbitral rules, and I point to certain prior awards as examples. Sometimes the client trust is regained, sometimes it's not, because that's what they wish to believe. But I think explaining the process from the beginning and the protections in place within an institution really helps.
Thank you. So when parties encounter arbitrators or decision makers with no prior relationship, what do you think helps generate confidence in their independence and competence? Is it reputation, appointment mechanisms, institutional frameworks, or something else?
Reputation, yes, certainly. Experience in the relevant field or the geography of experience. Another one is clarity around conflicts of interest. Help reassure parties that the decision makers aren't influenced by prior relationships or financial incentives. I had a conspiracy theorist client who suspected that the regional institution was aligned with my opponent, who happened to be founder of the institution some years back. So I was instructed late in the day after the tribunal was constituted. At the beginning of the hearing, my opponent implied there was some sort of repeat appointments with not only one arbitrator, but 2 out of the 3 arbitrators. So that didn't help. So there was no specific disclosure by the arbitrators on the repeat appointments. So after the opening of the case, I simply said, asked the arbitrators to disclose the circumstances in which they were appointed in our case, whether they were appointed in other cases by the same counsel or party simultaneously or prior to our case, and any other circumstances which they thought might affect their impartiality, independence, or create a perceived conflict of interest. I did this in addition to the usual disclosure the arbitrators had made. I think that puts everyone on notice that we had to be extra vigilant of perception of neutrality. What ultimately builds confidence is consistency. Institutions also create a framework within which neutrality can be trusted. Simple things like procedural standards, equal opportunity to be heard, clear timetables, predictable processes signal professionalism and fairness. They create a sense that the system is being applied evenly, regardless of who the parties are. Was that
Thank you.
helpful? Did that answer your question?
Yes, yes, it does. It does. Before we close, to end the conversation on a slightly lighter note, outside your professional roles, how do you usually switch off?
Good question. Very good question. Sometimes very difficult. I find spending time outdoors help me. Go for walks, staying active. I play tennis. I go for a swim if the weather allows. So yeah, sports is my go.
Thank you for this very thoughtful perspective that you have shared from the journey you had throughout your career, as well as the insights that you have shared in response to the questions. Thank you, Ms. Hikmet, for your time.
I see.
And even though the invitation was sent on a short notice, thank you for accepting.
Thank you for having me.
Yes. So perhaps down the line, we can have another session again if time allows. So
With pleasure.
once again, in this conversation, we had thoughtful reflections drawn from lived experience in international dispute resolution. These conversations are about how neutrality is lived, tested, and sustained. We look forward to continuing this dialogue in future episodes. And to all our listeners, thank you for joining us. This has been The Neutral Voice.
Thank you.